Welcome to the Trade Secrets. Intellectual property is one of these issues that touches everybody. This series is designed to help bring light to what this law is and how it works. Today, we're going to talk about the new frontier of jurisdiction in copyright cases. In the last episode, we looked at the granddaddy of jurisdiction cases, International Shoe. Now, we're going to delve into the details of the case that changed it all, Washington Shoe versus A to Z. Now, when this case came down, the stakes couldn't have been higher. Literally, what was at risk was the IP portfolios of Microsoft, Amazon, Washington Shoe, Adobe, and Getty Images. Intellectual property is this country's second largest export. And for these companies to be able to enforce their intellectual property on their home turf, well, that's what the case was about. So what happened in the Washington Shoe case? You had a Washington company, Washington Shoe, and an Arkansas company, A to Z Sporting Goods. They were doing business, obviously selling shoes. Well, what happened is A to Z ended up with some knockoff copyright infringement boots that they were selling in Arkansas. Washington Shoe told A to Z, "Hey, those are our designs. Stop that." A to Z said, "We're going to keep doing it." Washington Shoe said, "Fine. We're going to sue you, but we're going to do it here in Seattle." And A to Z said, "Look, this does not comport with the notions of fair play and substantial justice. We think you have to come to Arkansas." What in the Sam heck is this? You're suing me in Seattle? Now look here, we sent you a cease and desist letter. We asked you to stop selling our copyrighted designs, and you didn't do it. I'm from Arkansas. I sell boots in Arkansas. I sell sporting goods in Arkansas. You caused damage to us here in Washington, the rainy state. This ain't fair. It's fair that you get sued here. We'll see about this. So then the trial judge is like, I don't know what to do. First he decides for Washington Shoe, and then he changes his mind and decides for A to Z. The whole thing ends up at the Ninth Circuit Court of Appeals. In a groundbreaking opinion from the Ninth Circuit, they overruled the trial court's, in this case, second opinion, and found that jurisdiction did exist in Seattle because the copyright infringement was willful and it caused damage in Washington State. For the first time in 70 years, copyright holders and other intellectual property plaintiffs can take off their hiking boots and go to court wearing, essentially, their bedroom slippers. In the next episode, we're going to look at the trade secrets of acquiring jurisdiction against infringers and suggestions for infringers trying to avoid copyright infringement.
For more information about this series, visit us at thetradesecretsofintellectualproperty.com.